If every single rule of India's new digital personal data protection framework came into force overnight, companies wouldn't be ready. The result? Apps will start crashing, websites will start glitching, and users like you and I will start getting spammed with confusing privacy notices. It would lead to absolute chaos. The DPDPA introduces a wide range of obligations, notice and consent requirements, limits on how long data can be retained, and the creation of a data protection board, to name a few. But here's the catch. India has never had a data protection law before. The issues it tackles are complex and compliance demands a fundamental change in how businesses handle personal data. That's where phased implementation comes in. Phased implementation implies that instead of flipping a switch and having all provisions of the law come in at once, the law rolls out in stages. Different provisions come into force on different dates, giving businesses, especially startups and SMEs, the breathing room to adapt. And this is crucial because as data from our study reveals, a large share of Indian businesses have zero prior experience in complying with data protection norms. Without a gradual rollout, compliance would be more wishful thinking than reality. This is why Section 1, Subsection 2 of the DPDPA explicitly allows phased implementation. According to this provision, different dates may be appointed for the enforcement of different provisions of this Act. The draft Digital Personal Data Protection Rules 2025 take this a step further, dividing the rollout into two phases. Phase 1 begins immediately after the rules are published in the Gazette. This phase sets up the Data Protection Board, basically the watchdog that will handle complaints, issue penalties, and oversee compliance with the law. Phase 2 covers the heavy lifting stuff, the obligations that change how companies actually handle your data. Think redesigned consent notices, verifiable parental consent, and hiring data protection officers. But here's another issue. The rules don't give a fixed timeline for phase 2. That uncertainty matters. These are the most resource intensive changes requiring back-end IT overhauls, designing new consumer interfaces, and even hiring new staff. For users, it means we don't know when the promised protections will truly kick in. Realistically, businesses need at least 2 years to adapt. This is because incorporating data protection measures is significantly more complicated than it seems. Take consent requirements, for example. These are not just simple yes or no pop-up checkboxes that we're used to. Under the rules, notices must be available in all 22 languages listed in the 8th schedule of the Constitution of India. Today, most firms don't have consent notices, and those who do offer consent notices only in English. Expanding to 21 more languages isn't a simple translation exercise. It requires redesigning user interfaces, reworking backend systems, and building technical capacity from scratch. This is why 44% of the Indian MSMEs we surveyed said that they would need a full 24 months just to implement consent requirement. Verifiable parental consent adds another layer of complexity. Verifying a child's age and a parent's identity online is not only technically demanding, but also fraught with privacy and security risks. It requires a complete overhaul of existing frameworks. It requires businesses to establish new systems without compromising on user security. The rules demand processes that most firms simply don't have in place. And all of this is happening at the same time that companies must also prepare for a new layer of governance, hiring data protection officers. That is no small task. DPOs are required to have a deep experience in data governance, law, and technology, skills in short supply even globally. Competition for such professionals is intense, which drives costs up and timelines out. A 2023 study, even large firms admitted the hiring process would be moderately to extremely difficult, estimating it would take at least 6 to 12 months to secure qualified candidates. For smaller firms and startups, that challenge only multiplies. Interestingly, companies that claimed shorter compliance timelines were often those with zero prior experience with compliance. Firms that had navigated similar laws abroad consistently pointed to a 2 year horizon as the realistic benchmark. These examples suggest that lawmakers should provide at least a 2 year timeline for the implementation of the DPDPA. This is in line with international best practices as well. In the EU, Japan, Brazil, even California, 2 years is the norm. Brazil even gave businesses an informal extra 2 years before serious penalties kicked in. The logic is clear. Let companies build compliance systems properly rather than rushing into half-baked fixes. If India follows this model, we can expect a 2-year window for phase 2, plus maybe a leniency period of an additional year where the Data Protection Board focuses on guidance and not punishment. That way, businesses, especially MSMEs, can adapt without being crushed by compliance from day one. If India rushes the rollout of its data protection law, the result could be buggy websites, broken apps, and consent flows that expose personal data instead of protecting it. A phased approach avoids these risks, giving businesses space to adapt, ensuring the law delivers stronger and lasting safeguards.
This is the SCA Center. If you found this video useful, please like it and share it. You can also follow our LinkedIn page for more explainers and other updates.